Introducing you all to our moderator for the panel coming up, Sahar Sheikh. She's an advocate of the High Court and a managing director at an export firm. She holds a BA in law with a focus in policy and government and a minor in psychology from Carleton University, Ottawa, Ontario, Canada. Sahar is also an editor for of this anthology. She will be moderating the panel talk on tracing transformations in law anthology at the Decennial conference in Lahore. Sahar, please, now over to you.
Thank you, Noor. Assalamu alaikum to everyone here today. I hope everyone's having a good afternoon and enjoyed their tea. I just wanted to state a fact. I was just discussing with Nida about the women statistics of lawyers in Pakistan, and where Turkey is at 48.4%, Pakistan is barely touching 15%. So the women here need to step it up, get your sisters, get your wives, get everyone into law, and hopefully we can have it reflect the women's population, like Ms. Leila pointed out, that we're at 50%. So we need to have a better reflection of lawyers, especially for women in Pakistan. Right now we're gonna have a panelist discussion over a book that has been worked on really hard by a lot of the people that you'll see on stage today. And it's tracing the transformations in law, which, as you know, if you practice in Pakistan or if you live in Pakistan, the law goes through a lot of transformation here. And so hopefully, if we can have everyone's support and read the book, it would be a great help. It's for sale right at the back at the second booth. And it's a very good, interesting read for anyone who's following the law in Pakistan. First, I'd like to go ahead and introduce the panel chair, the Honorable Ms. Fozia Wikar. She's currently serving as a federal ombudsperson for protection against harassment at the workplace. She's an expert on women's rights and empowerment, recognized widely in Pakistan and globally. She's led the Punjab Commission on the Status of Women, where she pioneered gender disaggregated data collection for policy and legislative reform aimed at eliminating discrimination and violence against women. She has successfully placed gender equality at the core of the government processes and has served on many nonprofit, public sector, and corporate boards. She is the recipient of the prestigious Central Asian Regional Economic Cooperation. Please help me welcome Ms. Fozia Wikar. Next, we have one of our panelists, Ms. Sahar Bandial. Ms. Sahar Bandial is an advocate of the High Court with a broad litigation practice. Sahar holds a law degree from the University of Cambridge. She has particular expertise in matters that touch upon women's rights, including family law, workplace harassment, and gender discrimination, both through public interest litigation and legislative work. Sahar has also remained involved in policy and consultancy work with legislators, government bodies, NGOs, and international organizations, such as the World Bank Group and Equality Now. She has particular expertise in legislative drafting, including legislation governing rape law, domestic workers, involved in legal academia, and has for the last 10 years served as a member of the adjunct legal writing and the adjunct faculty of Sheikh Ahmed Hassan School of Law and LUMS, where she is primarily instructed legal writing and drafting. Please help me welcome Ms. Sahar Bandial. Next we have Mr. Hassan Niazi. Hassan is a partner at Common Law Chambers, Attorneys and Consultants, where he leads the firm's practice in constitutional, regulatory, and technology disputes. He is also the lead regulatory counsel for Meta Platforms Incorporated, which is based in Singapore. Please help me welcome Mr. Hassan Niazi. Last but not least, and someone who doesn't need an introduction, we have Nida Chaudhary, who is the founder of Women in Law, who is highly passionate and also an award-winning diversity and inclusion advocate, for all who don't know, and has over 20 years of teaching experience. Please help me welcome Nida Chaudhary. Okay, so I'd just like to start with a few questions for you guys today. Sahar, Bandial, I'm going to start with you first, if that's okay. Sahar has a piece in our anthology, Creating Safer Spaces for Women, Expanding the Scope of Harassment Law in Pakistan. Sahar, harassment law in Pakistan has moved beyond just sexual misconduct to include gender-based discrimination. Why is this shift important, and what difference does it make for women at work? So basically, we want to know why defining harassment as discrimination matters so much.
Thank you, Sahar.
No problem.
So yes, there's been a definite shift in the understanding of harassment in our legal system. And as I write in my paper, we've moved from a sexual misconduct paradigm to what I term the equality-based paradigm of harassment. And just to give context regarding the importance of this shift, I'm going to state some figures. According to World Bank report, about 48 million women are out of the workforce in Pakistan. The labour participation rate for women in Pakistan is just a little over 25%, and the global average is over 47%. 1 in 3 women feel unsafe in the public, and the pay differential between various professions in Pakistan between men and women ranges from 17 to 20%. And the very objective of this act, when it was promulgated, was to address this discrimination against women in the workforce and the exclusion of women from the workforce. We look at the statement of objects and purposes of this act, and it's quite clear that the purpose was to ensure working environments for women where, number one, they can work in a safe and dignified manner, safe from instances such as sexual harassment, but also, as importantly, to be working in environments that are non-discriminatory, where they're given equal opportunities with men. When we, however, look at the definition clause of in this act regarding harassment, ostensibly it appears more limited to sexual forms of misconduct. So it includes unwanted sexual advances, requests for sexual favors, verbal communication of a sexual nature. But sexual misconduct is only one aspect of the structural exclusion and discrimination against women in the workplace, which may manifest in different ways. It may manifest in the form of questioning female employees' ability and professionalism on the basis of her gender, not according her the same pay as a man in the same line of work, restricting her growth opportunities, her opportunities to learn, for instance. So these forms of conduct or this culture at the workplace is as responsible for excluding women from working environments, from the labor force, as is sexual discrimination. And this is why the shift in paradigm is so important, because it reflects a broader understanding of what women suffer at the in the workforce, what are the factors that exclude their participation from the workforce. And I quickly want to sort of note that this shift has happened over time. It has happened because the judiciary has taken a different stance, a different understanding of harassment. And in fact, in the Naz review judgment, which is critical, and you'll see how I cited in my paper, which is critical to this transformation and growth in the law. And we have Justice Aisha Malik here, who wrote that judgment. And in that judgment, she writes that harassment is not so much about sexual desires, but more so emerges from the imbalance in the power dynamic between men and women at the workplace. And this imbalance is what is responsible for creating opportunities and space for intimidation and discrimination against women. So the shift brings the understanding of the law to be more in line with the true purpose and spirit behind promulgation of the law. And number two, it reflects the actual lived experiences of women in the workforce. And just to note what kind of orders are coming out from relevant bodies after this shift. And we have Ms. Fawzia here, who is also responsible for pushing the law forward in this area. FOSPA has given decisions which have held that terminating a woman during her maternity leave is discrimination and amounts to harassment under this Act. FOSPA has also given a decision that requiring the widow of a government servant to produce a no marriage certificate before she can be entitled to receive certain benefits. That is also gender-based discrimination and can be agitated under this Act. So we have a broader understanding of what harassment means and what exclusion means, excluding women from the workplace, broadening the scope for actions that can be brought under this law, which is very important. Thank you.
Thank you very much, Sahar. It's very informative. I'd like to move on to Mr. Hassan. Mr. Hassan Niazi has a piece in the Anthropology about the prevention of the Electronics Crimes Act and how dissent became a digital crime. Hassan, I'd like to ask you that your paper shows that PECA quickly moved from being a protection law to a tool for controlling speech. What specific provision or practice best illustrates this shift? So we basically would like to know your thoughts in regards to which part of PECA has done the most damage to free speech.
Thank you, Sarah. So the reason we need to understand PECA from a women's perspective as well is when PECA was first introduced, now this is going back to 2016, one of the reasons given was that we need a law for the internet that will protect women from harassment, stalking, and so on. Now, while creating that law and protecting women from those harms was important, what actually happened was this ended up being a pretext. What the law was actually made to achieve became the suppression of dissent. And if you ask me for one provision, I think there are multiple provisions in the law that are problematic. But one is the extent of the power given to two authorities. The Pakistan Telecommunication Authority, which acts as the chief censor of online speech, and the second is the FIA, which has now been replaced by NCCIA. They have immense arbitrary power under this law to both censor speech and also to investigate people for alleged offenses under this. Now, when I say arbitrary power, let me ask everyone here a question. So the Pakistan Telecommunication Authority under Section 37 of PECA has the power to ask any online platform to take down content that might be locally unlawful. From 2018 to 2019, do you know which country sent the most content takedown requests in the world to meta platforms in?
Pakistan?
Pakistan. In the entire world.
Wow.
How many of you know what those requests were? We don't know. We don't know what they are asking them to block. The transparency reports that are coming from the social media companies are the only way we know. Right to information requests have been pending for a long time. We are not given that information. We are only told vaguely this much was removed from hate speech, this much was removed for glorification and terrorism. But the fact of the matter is we don't know what they think is hate speech. We don't know what they think is terrorism. Now, what they have done is they have enacted Section 26A. 26A says, and again a pretext was used. This time the pretext was, we need to counter misinformation and disinformation, which is essentially fake news. But how they define fake news is, they didn't define it. So anything can be fake news. Generally, if you look globally, when you try to regulate false information, yes, it is a problem. It is often defined as a statement of fact that is likely to cause some type of harm. So I'll give you an example of that sort of content. Misinformation against the polio vaccine. That is something we can understand because it has also led to deaths of polio workers. It has led to consequences for children. But let's say I say the state is complicit in human rights violations. Under 26A, this is an opinion, yet it would still come under the ambit of 26A because there is no carve out for opinions, satire, humor, analysis, commentary. There are no carve outs. So the state has this absolute discretion now over the truth. And what we have done is we have made it a criminal offense. So the state can say, we don't think we're complicit in human rights violations. Arrest this person under 26A. And the NCCI has done this. The FIA has done this. We know because there's a case right now in the media, Viman Mazari and Hadi Ali Chaudhary. What did they say? That was a false statement of fact. They gave opinions. But they have been imprisoned for their opinions. This sort of discretion is not only, in my opinion, unconstitutional because we must not forget that for all the laws that we have promulgated, Article 19 of the Constitution still exists. Now people may say it has restrictions. Yes, but we have also ratified the International Covenant on Civil and Political Rights. That means it is part of our local law. That means any restriction on speech must be judged according to legality, proportionality, and necessity. I assure you the PT is not doing this, the FI is not doing this, and the NCCI is not doing this.
Definitely. Thank you very much, Hassan. That was very informative, and I hope everyone here is reflecting on that. My last question would be for Ms. Nida Chaudhary. Nida, in your paper, multiple comparisons are made with the UK system. What concrete reforms would you suggest to make legal education more accessible, equitable, and in line with the global best practices?
Thank you so much, and thank you, Hassan. It does bring our light a bit because you're sharing this 10th anniversary with that of Nika's previous that also passed in 2016. But another very interesting thing that started happening around the early 2000s was that the Bar Council woke up to the fact that there's a mushroom growth of law colleges and that they needed to control them. There's so many law schools coming into the profession and there's not enough jobs and opportunities and the quality of the profession overall is falling and there's all sorts of anxiety about what the law schools were doing, what kind of graduates they were producing, and so we decided that they're going to now involve the Supreme Court in the process of regulating legal education without having a single PhD in their ranks. And that's where I started thinking as to whose prerogative is it really to regulate something like legal education. I mean, just because you are from the bar, does that entitle you to be able to make decisions about to make decisions that should technically be part of the autonomy of higher education institutions? These are decisions have to pay a certain sum of money to the bar just because you've decided to enroll in a law school. And what do the law students get in return for that amount of money that they're paying to the bar? Nothing. Zilch. Zero. Because when you ask them to set up a fund to support the law students who qualify for international mooting competitions, they say that students are not within our jurisdiction or that this is out of our scope. So, I mean, the kind of double standards I started experiencing because I teach and I engage with law students all the time. And through Women in Law, they've been coming to us for help and for support. And every time, like when they qualify for mooting competitions, and I see that there is no governance structure, not at the university level, not at the bar level. And yet, when it came to controlling what can be taught, controlling how many students a university can have. So the entire exercise, then you start questioning that. You start questioning whether A, bar is really the right forum to be doing this. How qualified they themselves are to be taking decisions on higher education matters. And also what impact that has on the autonomy of universities. And you asked about the comparison with UK, and I'd like to quote the Russell Group, which represents 24 leading UK universities, and it states that we believe a quality education, student choice, institutional diversity, competition, collaboration, and international competitiveness are built on a foundation of institutional autonomy. The freedom of universities to manage, teach, choose their staff and students, and that they are able to speak freely. The importance of that autonomy was recognized by the government's inclusion of it in the Higher Education and Research Act of 2017. Autonomy is also critical in enabling our universities to deliver for students across the Office for Students' fundamental objectives on access, quality, consumer law, and value for money. And I want to talk about access a little bit because they've also made classes mandatory in a brick and mortar institution, whereas the world is moving towards digital forums. I mean, I've done the University of London degree myself, sitting here in Pakistan. Yes, I did go to a local teaching institution, but I could have done it simply as an external student from my home. But over here, we want to regulate that also. We want to make sure that we don't open the access for women or differently abled persons who would have done this degree, but now they need to, in order for them to be able to enroll for their bar licenses, they need to be, present in a brick and mortar building in order to justify that they've earned that degree. So I mean, these are just quite, they're archaic ideas. I think that there is no space for such thinking. If we want to compete with the global community, we need to open up these spaces and we need the bar out of legal education. What they can do at their level is to institute a proper bar vocational course as it is in the UK and other jurisdictions. But at that level, there's not much institutionalization. It's just being few sporadic efforts by individuals like Mohammed who's done a lot to get a bar course started at the bar, but that's a 2-week course which is lecture-based, and even the bar's own exam is an MCQ-based exam, hardly, and it gives you about 7 to 8 chances to clear. The pass percentage is very low, so I'm really not sure why they're not putting their own house in order and interfering in the institutional autonomy of universities. Thank you so much.
Thank you very much, Nida. All very good and important points, and I think all the students here in law can appreciate that and probably have thought about those issues throughout their journeys and also had to face them. So hopefully we can change that around. And if you guys all enjoyed Nida, Hassan, and Sahar's comments and critiques, you can find them in the Tracing Transformations in Law book at the back, booth number 2. Just before we end here, I'd like to call up Ms. Fozia Wagar for her comments and closing speech. Thank you.
Thank you. First of all, congratulations to Women in Law for their 10 years. Must be a difficult journey considering that the gender perspective that we talk about so much is really absent, and it's a struggle, an uphill battle. I'd also like to appreciate and thank the contributors of the book, Tracing Transformations in Law. Good, insightful book and easy to understand, relatable. I'd encourage all of you to read that. I'll begin with thanking our panelists for 3 very rich, rigorous, and thought-provoking interventions. And what this panel had to offer us was not just simply a discussion of 3 areas of law, but a deeper reflection on how law in Pakistan is evolving, where it is succeeding and where it is under strain. For example, one of the most important insights of Sahar's analysis is the shift from understanding harassment as isolated sexual misconduct to recognizing it as a form of gender-based discrimination. This shift matters profoundly. It moves the conversation away from individual wrongdoings and towards structures of power, exclusion and inequality that shape women's experience of work. And that is a massive shift, because in my everyday life, when I deal with matters of harassment, it's very hard to make people understand the systemic realities which discriminate against women in the subtlest of manners, which is hard for a person, especially a person of the opposite gender, to understand because it is not their lived reality. So having a good law and that law evolving matters a lot. When harassment is framed as discrimination, it is no longer treated as an aberration or a personal grievance. It becomes a question of dignity, equality, and access, anchored in constitutional values under Articles 14, 25, 27, 34, and 37. And I really appreciate the role of the judiciary in invoking all those guarantees of not only constitutional equality, but dignity and inviolability of dignity of a person, as well as non-discrimination in employment, the need to have better representation of women in public spaces, etc., to anchor harassment law in these constitutional guarantees. Importantly, the trajectory of harassment law does not just reflect regulatory access or overreach, but it moves to a paradigm for introducing that enabling and safe workplace. It responds to a long-standing absence, a legal absence. And the 2022 amendments, for which I'm personally very grateful because they're coming in handy every day, they represent a corrective expansion, addressing forms of exclusion and invisibility that had legally gone unrecognized. Here, the challenge has been belated recognition and effective implementation, not restraint. An important point that I culled from reading Sahar's chapter was the evolving relationship between the judiciary and the legislature in shaping this regime. The law is developed through a form of institutional dialogue, sometimes uneven, sometimes contested, but ultimately oriented towards giving substantive content to dignity at work. It reminds us that progressive legal change often emerges incrementally through institutional engagement rather than grand legislative moments. And I'm happy to see that we've had similar examples in, for example, Anti-Rape Investigation and Trial Act of 2021, where the law has evolved through this institutional dialogue, through a feedback loop, not only from the legal community, but the civil society. And it has had incremental improvements like the Rawalpindi rape case in 2013 and the various institutional provisions that were introduced in that as guidelines to the banning of the two-finger virginity test by Justice Aisha Malik, who is sitting here amongst us, reported in 2021. And now we have other opportunity for this institutional dialogue and this feedback loop. I feel strongly in the Elections Act also of 2017, because the recognition, although belated, is there that the law can help in the citizen. Finally, Nida's chapter, I feel like brings it all together. It draws our attention to a foundational but often neglected question. How are lawyers formed? And I think she's given us an understanding of how lawyers are getting formed these days and who gets to participate in the legal profession. Her analysis, I feel, of the Pakistan Bar Council legal education rules demonstrates how a framework introduced in the name of quality control has, in practice, raised barriers to access, constrained university autonomy, and standardized legal education in ways that sit uneasily with global best practices. The comparative references from the UK are not calls for transplantation, and I assert that very seriously, because often, whenever something good is done and a best practice is adopted from another country, it is castigated as transplantation, unsuitable to the cultural realities of a country. So she's not calling for transplantation. These are invitations to think in terms of principles about accessibility, diversity of pathways, and respect for academic governance. What is at stake is not merely pedagogy, but the intellectual character of the legal profession itself. And her warning is a serious one, that excessive regulatory control risks producing lawyers trained primarily in compliance rather than critical thought. This again is a very important point, because in my dealings with lawyers on an everyday basis, I see that being translated into arguments, into thought patterns which are essentially discriminatory. And I'll give you some examples, and I think Sahar also mentioned about some of the decisions that have come out of FOSPA. When a prejudicial mindset is talked about, for example, by the Vice Chancellor of a university, the rest of the university and the lawyers representing them do not understand that it is squarely covered under the law, and it is that prejudicial mindset which ends up in discriminatory practice against a woman, who will end up not getting promoted because of that discriminatory mindset. Similarly, for example, even beneficial legislation, such as putting a cap on a woman's ability to contribute under the employee's old age benefit insurance at 55, while seen as a beneficial action so that she can claim eligibility at an early age, and may end up discriminating against her because her ability to contribute for 15 years is seriously compromised, Similarly, Sahar talked about the Prime Minister's family assistance package, made for a good cause, but says that a woman, if she gets married, if she has a job after the death of her husband, when she gets remarried, she has to give up her job, otherwise she doesn't have to marry, So the choice is between her keeping her job or not being able to marry. And that is a difficult choice to make. And the underlying message is that a woman should always be dependent on another man. So now that she's found another man to rely on, the job is taken away from her. I have multiple other examples. For example, recently I came across the practice, not the law, but the practice of denying rent of a building to single women and men. Now we know that this goes against constitutional guarantees of equality, but it is accepted in the name of protection from terrorism, protection from prostitution, without clarifying that those are actions that they are illegal, that should be prevented. But you can't deny an opportunity to a woman, for example, who's come from Karachi to Lahore to rent a building, and that single denial is going to shape perhaps the rest of her life. Important issue to make. Or excessive CCTV monitoring for purposes of sexual harassment in this case. So, I think I should wrap up. Across the three contributions, a common concern emerges: the relationship between law and institutional power. Women's trust in workplace mechanisms, citizens' trust in digital regulation, and students' trust in professional governance are all shaped by law by how institutions exercise authority. Law can either repair that trust or erode it further. Protection can empower, but it can also discipline. Regulation can ensure standards, but it can also silence. What we need now is that to understand that while in some areas, such as workplace harassment, the work of the law has been to catch up with lived realities, but also to understand that particular digital regulation and professional governance has had the effect of pulling the law back into alignment, into non-alignment with constitutional limits, and that is where we need to move. Let me conclude by thanking our panelists for scholarship that does not offer easy answers, but it asks the right questions. These chapters remind us that law is not merely a technical instrument, it is a living conversation about power, dignity, and justice. Thank you very much.